In this final episode, let's examine several specific cases to gain a deeper understanding of the U.S. Supreme Court. We'll look at issues like racial discrimination, gender equality, and the Miranda warning, that phrase we've heard countless times in American TV shows. You have the right to remain silent. Anything you say can be used against you in court. In our previous episode, we discussed how during the 1960s, when Earl Warren served as Chief Justice, the Supreme Court became a vanguard for social change. While this genuinely advanced social progress, it violated the principle of judicial restraint by using the court as an accelerator rather than a brake. In some cases, the court went too far, proving that excess can be as problematic as deficiency. We all follow the law to reduce the cost of running society. When judges make forceful rulings on issues where most citizens haven't yet formed consensus, it inevitably creates social division, even intensifying conflicts. Therefore, some argue that Warren's Supreme Court left America with quite a mess, a claim that isn't exaggerated. This raises a question. Warren resigned in 1969, while the current Chief Justice Roberts only took office in 2005. Between them served Chief Justices Burger and Rehnquist, both conservatives. During Rehnquist's tenure, conservative justices outnumbered liberals by a striking 8-to-1 ratio at one point. So why didn't Rehnquist correct Warren's excesses? I believe there are two reasons. First, in America, while Democratic liberals and Republican conservatives appear irreconcilable, they actually share the common goal of pursuing societal good. They differ only in their methods. Liberals believe that achieving the common good, collective interests, requires sacrificing some individual rights. Conservatives, conversely, believe that to achieve the common good, we must defend individual rights. Both sides agree that racial discrimination is wrong and that gender equality is right. They differ only in their preferred paths and pace of implementation. It's like driving. If someone ahead speeds, those behind should slow down, but there's no need to turn around and go back. Second, America follows common law, where precedent strongly binds judges. Rehnquist particularly respected precedent. He said the American judicial system is like a massive ship not designed for sharp turns. If he had completely overturned Warren's decisions, American society would have experienced violent left-right swings, something Rehnquist desperately wanted to avoid. Rehnquist often quipped, "I've done nothing, and I've done it extremely well." I personally have great admiration for Rehnquist and believe he possessed genuine wisdom. So, what exactly were these problematic legacies Warren left behind? For instance, racial discrimination is clearly wrong. But the oath describes a case where the New Haven Fire Department held a promotion exam, and the passing rate for black candidates was less than half that of white candidates. The department decided to invalidate the test results and conduct a retest, a decision that angered those who had passed, prompting them to file a lawsuit. The lower federal court ruled in favor of the fire department, supporting the decision to retest. The case reached the Supreme Court, which ruled, "Isn't this nonsense? Regardless of race, tests must have one standard. That's what non-discrimination means." I share this example first to illustrate the absurd extent of political correctness in America, and second to give you an overview of the current liberal stance in the Supreme Court. Regarding racial equality, liberals advocate for compensatory bias toward minorities. Essentially, a black person scoring 80 points will be considered equivalent to a white person scoring 100. That's roughly the concept. Conservatives consider this reverse discrimination. They believe true racial equality should follow a colorblind policy, meaning a person's evaluation shouldn't include skin color as an assessment parameter. Logically, the conservatives' colorblind policy makes the most sense. However, liberals counter with this analogy. Imagine tying up a black child for 5 years, then at age 5, untying him and letting him race against a white child. When he loses, you say, "I gave you a fair chance to compete. It's your fault if you lose." This is clearly unfair to the black child. What constitutes true fairness? Philosophers debate this too. John Rawls advocates for compensatory justice. If you previously mistreated someone, you should now offer preferential policies as compensation. Robert Nozick supports procedural justice, using fair procedures and equal opportunities to justify unequal outcomes. You might not be familiar with these philosophers, but I mention them to help you understand both perspectives. Both sides have valid points. The focus of the issue is, when does white compensation to Black Americans end? There was certainly a debt, but there must be a point when it's fully repaid. Former Justice O'Connor once proposed in a case, "We've been compensating Black Americans for 25 years. How about 25 more?" suggesting that 50 years of repayment should be sufficient. However, Thomas, the only Black justice, disagreed. "The greatest fairness to Black people is leaving them alone. Let them stand on their own 2 feet. If they can't stand, then let them fall." Similar debates arise regarding interpretations of the Brown versus Board of Education legacy. Before Brown, the policy was separate but equal. Public schools were segregated. Black students attended Black schools. White students attended white schools, as long as the facilities were equivalent. Some Black families lived very close to white schools but far from Black schools and requested to attend the nearby white schools. Previously, this wasn't allowed because of segregation. Without debating whether the Brown decision was right or wrong, its essence was that children should attend schools based on proximity, not skin color. The Brown decision itself wasn't problematic. However, many American public schools today, fearing accusations of racial discrimination, admit students based on racial quotas rather than proximity. For example, if a city has 2,000 white children and 1,000 Black children, then regardless of whether Black families live near a particular school, Black children must constitute 1/3 of the student body. However, most Black and white communities live separately, with few mixed neighborhoods. If every public school must maintain proportional racial mixing, children often end up traveling farther to attend school. Under Chief Justice Roberts, compared to his predecessor Rehnquist, there's been a clear correction. In cases involving abortion, gender equality, racial discrimination, and other issues, Roberts and other conservative justices haven't taken a start-over approach. Instead, they've advanced incrementally, gradually reducing the scope of war-and-air decisions until they become toothless tigers. Beyond scaling back racial equality measures, they've also reined in gender equality. Consider the case of Lilly Ledbetter versus Goodyear. Ledbetter, a regional manager at Goodyear, discovered just before retirement that she had been earning $1,000 less per month than her male colleagues in the same position. Goodyear argued, according to Title VII of the Civil Rights Act, if you feel discriminated against, you must file a lawsuit within 180 days. How many years has it been? I think Goodyear's argument was unreasonable. Salary information is confidential. They underpaid her for so many years, and she had just discovered it. However, ruling in Ledbetter's favor would have serious consequences. Afterward, no company would dare pay women minimum wage. Regardless of performance, they would need to ensure at least one unfortunate man earned less than female employees to avoid accusations. This would infringe upon employers' rights. Can I determine how much to pay someone I hire? Since hiring women would become so complicated, employers might stop hiring them altogether. Thus, excessive government intervention supposedly protecting women would ultimately disadvantage them. Robert's Supreme Court neither declared the Civil Rights Act unreliable nor stated that Goodyear had the right to pay anyone any salary. It simply ruled that Ledbetter was entitled to compensation only for the most recent 180 days, effectively supporting Goodyear's position. Some war-and-era legacies, however, may be untouchable, like the Miranda warning. You have the right to remain silent. Conservatives complain that the Miranda warning overprotects suspects' rights, significantly hindering police investigations. Yet even the most staunch conservative, former Justice Scalia, recognized that overturning the Miranda warning was unlikely. He said, "How many people worldwide have heard of this warning? At least 2 billion. For America to now declare it invalid would be untenable. No matter how excessive Warren's actions were, what's done is done. A series of rulings over the years has profoundly changed American society. Completely starting over is neither possible nor necessary. However, in the next 2 decades, the Supreme Court's rightward shift will continue gradually erasing war-and-era legacies. That's the general direction. The Republican base has been changing in recent years, with evangelical Christians comprising an increasingly significant portion. This has caused divisions within the Republican Party, essentially splitting conservatives into non-religious conservatives and faith-based conservatives. On issues like abortion, there are major divisions even within conservative ranks. The oath describes how conservative-appointed Justices O'Connor and Souter sided with liberals in supporting abortion rights, while more Christian-influenced conservative justices opposed it. In conclusion, Tocqueville once said, "All political questions in America eventually become judicial questions." But he only saw one side of the coin. The other side is that all judicial questions in America ultimately become, to varying degrees, political questions. The mechanism of presidential nomination for justices inherently makes it difficult for the Supreme Court to completely escape partisan politics. Using the Supreme Court as a brake to prevent dramatic societal upheaval is best for the entire nation and society. Both American conservatives and liberals understand this deep down. I hope that Robert's court possesses Rehnquist's wisdom, moving slowly and steadily. After all, there's plenty of time, no need to rush. I'm Oliver, and we've now completed our analysis of the oath. Looking forward to meeting you in the next program.